Yeah, I'm going to stop sharing this screen now as everybody's coming in. Um, Again, I'd like to welcome everybody to our fourth webinar. I can't believe we're on number 4 already. So for those who don't know me, my name is Niamh McCarthy. I manage the Parental Advocacy Service and Information Service, which is delivered by Barnardos and supports parents navigating the childcare process. I'm joined today by Stephen Cahill, who has generously given up his time for these webinars, and he is the managing solicitor in Chancery Street. And just to say, some of the topics we've covered already has been the um, role of the role of the solicitor within childcare cases, how we apply for legal aid, and what the courtroom experience is like for parents in this situation. Daisy will put all links to those recordings in the chat as well, and you can find more information about them on both the legal aid website and Barnardo's website as well, and the parental advocacy page as well. Um, and I think from those webinars to date, we've got a lot of questions have come through. So today it's really about what questions Stephen gets asked a lot by parents in these situations that he's representing. And I would just like to take this opportunity to welcome any parents who are on the call today. And I know this will be a great resource as well in the future for parents. And a special thank you to all the parents that have submitted questions to put to Stephen today as well. I have to say we've received a lot of questions ranging from, I think, access with our children to what the roles of the different players within the court system are, to the court process as well, to private family law. So we'll do our best to get through as many as we possibly can. Um, I just might let Stephen introduce himself a little bit now. So I'm going to hand over. You're just on mute, Stephen.
Sorry, I'll try that again. So thanks very much for that. So my name is Stephen Cahill. So I'm the managing solicitor here in the Chancery Street Legal Aid Board office. That's a specialised legal aid board centre that deals primarily with childcare matters. And we're actually co-located with the childcare courts here in Chancery Street itself. So childcare comprises 95% of our kind of day-to-day practice.
Great. Busy spot, I would imagine. And Stephen, one of the things, like you obviously have a lot of experience in childcare matters and things. So what are the most common questions that you get asked by parents in this situation?
I think there are quite a few that tend to kind of crop up most commonly. Firstly, in the first instance, a parent is usually just asking you what is the, I suppose, the type and nature of the court case that they're facing, asking you to explain, what is a supervision order, what is an interim care order, and so on. But once you get over that kind of initial kind of few questions, one of the most common ones is you find yourself being asked, if my child is received into care, will I be allowed to see them? Will there be access and contact? So there's a real concern and I suppose misapprehension that if a child is received into care, particularly on an interim basis, that there wouldn't be access and contact facilitated, when there absolutely would and should be as much contact as possible taking place. So they tend to be the most common questions that pop up.
Yeah, and similarly, that was one of the most common questions that came up when we talked to parents as well. And they really wanted to know what the difference is. You often hear the phrase access is at the discretion of Tusla, or that'll be arranged with your child's social worker. What's the difference between court appointed access and then access at the discretion of Tusla?
So when an interim care order is made or extended, or even a care order is made, access is usually directed to be what's called, in accordance with Section 37, And that obliges the Child and Family Agency to provide a reasonable level of access. But what constitutes the reasonableness and the amount of access is then left up to the discretion of the Child and Family Agency. The difference, whereas if you have a more specific court order for access, is that that would direct a particular level of access, a particular frequency type of access. So it might say access 3 times per week plus a phone call, for 2 hours, and would be more directive and more specific.
Okay, so if a parent is working alongside tools and they have their access arrangement in place, but they're unhappy with the time or dates, and they can't come to an agreement, would they then request their solicitor to apply for an access order within the court to get if they could not agree with outside of court?
Yeah, so of course, ideally, access would be able to be agreed between all of the parties, but that simply just doesn't happen quite frequently. So your solicitor then should, I suppose, set out the kind of the pathway to you as to how you might go about bringing an access application. So in the first instance, it would be suggested that, speak directly to the social worker, put forward your proposals, what kind of access you'd like, when and where, and so on. And if that can be agreed, great. If it can't, then the next step would be for your solicitor then to issue formal correspondence to the solicitors for the CFA, again, setting out your proposals. And I suppose warning that if they can't be agreed, then an access application might become necessary. And if that letter doesn't kind of get things moving, then yeah, it's absolutely appropriate to issue an access application on behalf of a parent and to seek an order for the access that you're looking for if it can't be agreed by the Child and Family Agency.
Okay, yeah. And most commonly, there's a number of steps that happen before that, as you've just outlined as well. One of the other common, and I think you've just touched on this as well, that came up for us as well was around the different types of care orders. And I know you just said there that was one of the most frequent questions you get asked. And I suppose delving a little bit deeper into that, some of the parents we worked with was asking if their child is on an interim care order, when is it reviewed?
So an interim care order, if granted by the court, lasts for only up to 28 days, unless both parents or guardians might agree to a longer period. So while a child is in the interim, so the temporary care of the Child and Family Agency, the matter would be returning to court usually every 28 days. Or
Okay.
if there's something particularly urgent, the court might set a review even within that 28 days. But typically, interim care orders roll on a 28-day basis.
Yeah. And for the other question was around a GAL, a guardian ad litem. So is it very common that a guardian ad litem will be appointed to every case that's in court, regardless if you're on an interim or a full care or how does that work?
So guardians ad litem are appointed by the court, and that practice does vary somewhat from district to district. Certainly
Okay.
in the Dublin Metropolitan District, the childcare courts in Chancery Street, a guardian ad litem would be expected, I suppose, to be appointed in pretty much every case. That isn't necessarily the case in districts around the country, but in Dublin, at the time, even before an interim care order application is heard, a court might appoint a guardian in order for the guardian to give their views and so on for that initial application.
And why would the court think it's important to have a guardian on every case?
So since the amendment to the Constitution, Article 42A, there's a constitutional imperative that the child's voice, views and wishes be ascertained insofar as practicable. And the court, in making its decision, has to have due regard to the child's views and wishes. So even though the child is the subject of the application, they are individual rights holders in their own rights. And the court has to vindicate their rights, not just the rights of the parents as well. So it's to give effect to the constitutional imperative that guardians are routinely appointed.
Great. So if a parent is going through an interim care order, and we spoke the last day about reports that are issued, and I presume a guardian will issue a report as well. And will the parent have access to those reports?
Yeah, so the guardian will prepare a report for each court application, and that should be furnished to the parents' solicitor as well in advance. So that gives the solicitor time to go through the report with the parents, and then effectively it's a précis of the guardian's evidence. So it kind of sets out if the guardian were to be called to give evidence, what they would say to the court. So it's to give a parent an opportunity to know what inquiries has the guardian undertaken. Have they been meeting with the children? What the children have said to the guardian, and then what recommendations the guardian's making to the court as this independent childcare expert.
Thanks for that, Stephen. And I think so as we're moving back through into the care orders, one can an interim care order be put in place for a year, or what's the longest time it can be in place?
So there's no defined upper limit. So as that ordinarily interim care orders are 28 days unless a parent agrees to a longer period. So in theory, there's nothing to stop an interim care order being put in place for 12 months on consent. But I think the Child and Family Agency, and in fairness, the court and guardian ad litem would recognize that interim care orders are really only supposed to be pending determination of the care order application. So it would be more appropriate to have a hearing for it and then look for a short care order rather than a long interim care order. But in theory, there's nothing to stop it.
Mm. Yeah, and that was one of the questions that kept coming up all the time from our parents. If their child is then subject to a full care order, even if it's for a short period of time, how do their rights change?
So a Section 18 care order is a more intrusive, it is a more serious order than the Section 17 interim care order. It does involve, and I suppose a part of that is a more fuller transfer of parental authority to the Child and Family Agency.
Okay.
So while a child is under interim care, for example, the Child and Family Agency still need the consent of the parents for a number of matters, for medical treatment, to travel outside the jurisdiction, and so on. But once a care order is made, even for a short period, the agency no longer requires that parental consent. Now, a care order is still not akin to or like an adoption, but it is a more serious intrusion into the parents' rights.
And if a full care order is granted, even for a shorter period of a year or 2 years, um, whilst as a parent, I may not have to give my consent for my child to go on holiday or receive medical treatment, will I still be kept informed?
Oh, absolutely, and that's a matter that has been, I suppose, considered by the superior courts, and it's very clear that, as I said, a care order, even if granted right up until a child is 18, is not an adoption, and the parent should always be kept included, be involved in all the care planning, decision making processes, and so on. So even under a long care order, there's a legal obligation on the Child and Family Agency to still look at and consider reunification at each and every child in care review, which has to take place at a minimum every 12 months. And further to that, it's always open to a parent to come back to court during or while a care order is in being. The door to the district court is always open. So, notwithstanding a care order being in place, if you have issues around access or some other welfare issue, you can always apply to the district court for orders and directions.
Okay, very interesting. And I think particularly for a lot of the parents we would work with as well, often are very frightened about full order hearings, and they really would like to know what to expect from a full care order hearing. What does it mean? Like, I think you've explained what it means for the child and the parents, but for those few days, is it a minimum of 3 days? Is it a maximum, or what can they expect from it?
So it varies hugely from case to case. But at its core, it is a fresh application for a very serious order. And like with any application, if the Child and Family Agency are asking the court to grant an order, the judge has to receive sufficient evidence for the court to make that order. So the
Okay.
Child and Family Agency do that by calling their witnesses. And then for the parents, it's up to them. The parent solicitor will talk to them about maybe calling their own witnesses. Maybe the parents may wish to give evidence as well. So it'll be a full hearing, and depending on the nature of the case and how contentious and how contested it is, that will dictate how long the case might take. It may take half a day, or it may take a number of weeks in the more extreme
Okay.
circumstances.
And as a parent, should I always give evidence?
It's very, very case specific.
Okay.
Um, the burden of proof is on the Child and Family Agency. They're the ones who must prove their case. It's not up to a parent. You don't have to give evidence to disprove it. But quite often, a parent is the person best placed to rebut some of that evidence. Now, there may be circumstances where your legal advice is to not give evidence. And that again could be based on other considerations, even outside of the care order. So, for example, everything that's said in a childcare court is recorded, what's called the digital audio recording, the DAR. And the difficulty some parents face is, depending on the nature of the CFA concerns, it may be that there's a parallel Garda investigation, and it's open to the guards to apply to court at a later stage to take up a copy of that court record, in effect, and
Okay.
that could be used against you in the criminal courts. So a parent sometimes has to be very carefully advised as to the risk of either self-incriminating or prejudicing the defence to any potential criminal matter that may come down the line. But that's in more kind of extreme circumstances.
Yeah. And that's really interesting. So can the DAR also be used in family law courts as well if one child, for example, is to a private family arrangement, possibly with a different parent, or and the other children are subject to care orders.
Yeah, so in every courtroom, the DAR is in operation, and it's just something to be aware of, I suppose.
Yeah, and if I'm a parent who gives evidence under for an ICO hearing, for example, could my evidence then be played in the family law if there was an issue around guardianship or custody for a different child?
I think it potentially could. It's quite there'd be a number of kind of legal steps and
Yeah,
obstacles for someone
okay.
to overcome if they wish to do that. But again, in theory, it's possible. Yeah.
Okay, very interesting. Um, Just one question around people had around their legal aid. I know we covered how you apply for legal aid and go through all the steps, but if it's a new application, essentially, the full care order, would a parent have to go and reapply for their legal aid cert, or does it follow them the whole way through each process, each step?
No, so you wouldn't need to reapply for the care order application. I suppose it's part and parcel of the defence of the childcare proceedings in general. So if you've been served with an application for an interim care order, the application for the care order is served usually at the same time. So your representation and your legal aid covers you for the whole lot. And for as long as the matter stays live, your legal aid certificate will remain in place as well.
Yeah. Okay. One of the most common things that come up as well, and I think we probably need a whole webinar on this, but just to briefly touch on it, was as part of the court process, sometimes there's an order for a parent to undergo a parenting capacity assessment. And this can be very confusing for parents, particularly who is it that makes the recommendation for a parenting capacity assessment, and can the parent ag agree or disagree to this process, and what are the potential outcomes of that?
Yeah, so I suppose traditionally parenting capacity assessments were routinely carried out by the social workers
Mm,
themselves. That's a practice that has changed over the last number of years. It's now more common that the social worker would seek, in effect, to outsource this assessment with a view to bringing in outside expertise. So usually they would suggest, so not just a parenting capacity assessment, but what's called a psychological parenting capacity
okay.
assessment. So it's an assessment conducted by usually a psychologist. Um, the district court can't make an order compelling a parent to undertake such an assessment. And I think the voluntariness of engagement is a really core and important aspect of it. So a parent can't be forced to engage in such an assessment. But there is a certain reality if their child has gone into interim care and the CFA say they need to do a fuller assessment of that parent's capacity or ability to meet that child's needs, and then the parent doesn't engage or refuses to engage, it makes it very difficult for that parent to
Mm,
advance reunification. So if a parent is open to engaging in a parenting capacity assessment, it should be done in as fair and a transparent manner as possible. So ordinarily, the CFA might suggest 3 or 4 names of potential assessors, and then it's open to the parents to decide whether they are agreeable or if they wish to suggest somebody themselves. So that's quite common. And then after that, you need to get down into the nitty gritty. So agreeing what's called a letter of instruction and terms of
okay.
reference. So kind of setting out exactly um, what questions the assessor would be asked to answer.
Okay. And if I was, as a parent, agreeable to undertake the PCA, and we'd agreed the terms of reference, and I understood very clearly what the process was, what to expect, but when it was conducted, I was really unhappy with how the process went, or how the assessments were laid out to me. Where where do I raise those concerns?
So there's a few kind of avenues open to you, I suppose. If there's a concern that the assessor acted um, improperly or unprofessionally or something like that, then one of the avenues of redress, I suppose, is a complaint to their professional body. So that might be the Irish or the British Psychological Society, something like that. But if, in terms of how it impacts on the court process, if you're concerned that an assessment wasn't robust enough, or even if you just disagree with the conclusions reached, it's always open to you to perhaps look for a second opinion. So you're not necessarily stuck with the first assessment you get, but where that assessment is done on a joint basis initially, it might be more difficult to get sanction, say from the legal aid board, to pay for a second assessment.
Okay, okay. They're all very complex, aren't they? It's a lot to
Yeah.
take in the whole process as well. And um, when these recommendations are made at the end of a PCA, and for example, if I'm the parent undergoing it, and the recommendation is that I receive trauma specialist counseling and addiction services, is it my responsibility as the parent to source those therapeutic services, or and how will they be funded?
So my own view is that if the Child and Family Agency wish to procure certain assessments that make recommendations, then it's incumbent upon the CFA to put them in place, to support a parent, put them in place. Because otherwise you could have a situation where the CFA say that in order for reunification to occur, we need a specialist service. But if that specialist service isn't available to you without paying for it, or if you simply couldn't afford it, for example, there's a huge unfairness issue arising there. In fairness to the agency, it depends. In many circumstances, would be open to certainly helping the parent source the appropriate services. And that's usually a specific term put in the assessment or in the letter of instruction to the assessor, that if they are recommending certain services, that it's on the basis that they would actually be available to the parent.
Okay.
But then even after that, it's open so the parent can try and source, with the assistance of the CFA, of course, and maybe their solicitor, try and source any recommendations through the public services. And only then, if they're not available at all or in a timely fashion, then it might be appropriate to bring an application to court compelling the CFA to pay for it if they're not agreeable.
Okay, really interesting. As I said, that's a whole topic about on itself. So,
Yeah,
I know we
absolutely.
have a question in the chat as well, but just one of the most common questions coming through at the minute. We know that there's a lot of pressure in the CFA at the minute, in terms of resourcing and all of that, which can't be helped. But one of the main things that is coming through, what if my child is subject to an interim care order, but there's no social worker allocated to the case or no stable placement for my child?
So ordinarily, when certainly in the Dublin courts, when or if the judges make a care order in particular in respect of a child, they'll usually make a number of other directions alongside that care order. And they're to address two of the very serious issues that you've just kind of outlined there. So the court and the national standards demand that each child in care has an allocated social worker. And the courts in Dublin recognise the importance of that. And when a care order is made, it's routine that a direction is there that if there's no allocated social worker for a period of, say, usually it's 4 to 6 weeks, that the CFA are to re-enter the matter to
Okay.
court. And then the other issue you've raised there about placement. So the court would make a similar direction that in the event of a change of placement, that the Child and Family Agency are also to re-enter the matter to court on notice
Okay.
to the parents and also automatically reappointing the guardian. And the judges in Dublin sometimes would even specify the wording. So even if there's a concern of a potential placement change, that the matter is to be re-entered to court. So there are two matters that are treated very seriously by the courts, particularly in Dublin.
Yeah, yeah. And I think when you are in a resource crisis like that as well, it's difficult for the CFA as well to be able to meet those needs as well. But ultimately, it's the best interest of the child that has to be at the center of all of this. One of the questions, Stephen, that has just come up in the chat has been around, are parents still the child's legal guardian if a care order is made?
Yes, so a care order doesn't remove guardianship, but the reality is that a care order infringes upon some of the usual rights and obligations a parent as a guardian would have. The main one being, what I've talked about earlier, just being consents, for example. So even though you are a guardian, because of this transfer of parental authority under a care order, your consent is no longer required to matters. So guardianship is technically not removed, but a lot of it does kind of fall away if a care order is made.
Okay. And I think the time has just flown by again. So we're just at the end, but I would like to end with what, like, one thing you wish parents knew going into a care process.
I suppose if they knew that care proceedings are separate and distinct from adoptions, that a child being received into care is not like an adoption. It does not sever that family ties like an adoption does, and that the door of the district court is always open. So even if we reach a point where a court makes a care order until a child is 18, that's not the end of the road. That it's open to a parent to come back to court on any number of issues, such as access, welfare issues, and so on. But it's also open to a parent to look to discharge the care order at any point as well. So if at a point in time, following on from the making of the care order, your circumstances improve or you've addressed maybe previous concerns, you can come back to court to look to get rid of that care order. So even the making of a care order is not the end of the road.
Thanks so much, Stephen. I think it's really interesting as well. There's just so much nuance and complexity to it as well, and you've been able to break it down really simply for us as well. We had loads of questions today, and we'll continue to gather everybody's questions as well. And our next webinar is going to be on the December 17th, which will be focusing on kingship care and non-relative kingship care. We really appreciate everybody's feedback as well. So if this works for me, yes. So Tuesday, the 17th of December at 1 p.m. again. What is kingship care and non-relative kingship care? And if there's any questions you have in order to help us prepare for that webinar, please put them in our feedback form as well, which you can scan here. I'd like to thank Stephen again for his time today in breaking down really complex information to really accessible form for us. And thank you to all who have come and joined us and for your questions and your interest in the webinars. I'm going to leave this slide up for a few minutes so that people can scan the feedback form. And thank you very much again.